By slashing a federal gun tax to $0, the government may have accidentally dismantled its own regulatory framework. A federal court ruling has declared key registration requirements of the National Firearms Act unconstitutional, triggering a countdown that ends at midnight tonight, August 12th. With the expiration of a 7-day stay looming and the Department of Justice remaining silent, advocacy groups are preparing to bypass federal paperwork entirely, leaving the future of gun control hanging by a thread. This sudden legal shift exposes a massive structural vulnerability in how the United States regulates firearms, turning a minor tax adjustment into a constitutional crisis that could reshape the legal landscape overnight. To understand how a tax cut created a constitutional crisis, we have to examine the foundational architecture of the National Firearms Act of 1934. For nearly 90 years, the federal government has regulated highly restricted items like suppressors, short-barreled rifles, and short-barreled shotguns, not through an outright ban, but through the power of taxation. Under this system, acquiring these items required a $200 tax stamp. This fee was the essential constitutional hook, as the Supreme Court of the United States historically upheld the registration system under the taxing power granted to Congress in Article 1, Section 8 of the United States Constitution. But a systemic shift occurred when Congress passed legislation reducing the transfer and making taxes for these specific items from $200 down to $0. While this appeared to be a victory for gun owners, it set off a major legal chain reaction. In the United States District Court for the Northern District of Texas, Judge Mark Hendricks recognized a fatal flaw in this framework. If the tax is $0, the government is no longer collecting revenue, meaning the measure can no longer be constitutionally justified under the taxing power. The Department of Justice scrambled to defend the system, arguing that the Interstate Commerce Clause could step in to save the registration requirements. However, Judge Hendricks rejected this defense, ruling that the executive branch cannot retroactively swap out the constitutional justification for a law once its primary mechanism has been dismantled. Consequently, the court granted summary judgment to the plaintiffs, declaring the registration requirements unconstitutional for the affected items. By stripping the financial mechanism from the statute, the legislature inadvertently severed the constitutional cord that kept the entire regulatory apparatus connected to federal authority. Without a tax to collect, the registration system ceased to be a tax program and became an impermissible regulatory mandate, leaving the federal government without a solid legal foundation to stand on. This ruling struck at the very heart of the National Firearms Act, but the judge issued a temporary 7-day stay to give the federal government time to react. That 7-day window closes at midnight tonight, August 12th. As the deadline approaches, the silence from the Department of Justice has been deafening. Federal prosecutors have a clear runway to appeal to the United States Court of Appeals for the Fifth Circuit, yet they have not filed a formal appeal or requested an emergency extension. This inaction has created an extraordinary state of suspense, raising the question of whether the federal government is prepared to let a cornerstone of gun control policy quietly lapse for these specific items. But this silence should not be mistaken for surrender. Legal analysts point out that the Department of Justice frequently utilizes late-night emergency filings to halt adverse rulings just before they take effect. This exact playbook has been deployed in previous Second Amendment battles, such as when the state of California rushed to the United States Court of Appeals for the Ninth Circuit after business hours to secure an emergency stay on magazine capacity limits. The federal government retains the power to file a motion with a rotating motions panel up until the very last minute, meaning a sudden, midnight intervention remains a distinct possibility. The strategic calculation behind such late-night filings is clear. It minimizes the window for plaintiffs to respond while preventing a gap in regulatory enforcement. If the Department of Justice waits until the final minutes of the stay, they can catch the opposition off guard and freeze the ruling before any transfers can take place. This high-stakes game of legal chicken keeps the entire firearms industry in suspense, as a single electronic filing submitted at 11:59 p.m. could instantly shut down the transition that advocacy groups have spent the week preparing for. While the Department of Justice hesitates, the plaintiffs are actively preparing to exploit the opening. Under normal circumstances, acquiring a suppressor or a short-barreled rifle requires submitting a Bureau of Alcohol, Tobacco, Firearms, and Explosives Form 4, a process involving fingerprinting, background checks, a $200 tax payment, and wait times that can stretch for months. This administrative barrier has historically acted as a major deterrent, keeping these items out of the hands of the general public through sheer bureaucratic friction. If the stay expires without intervention, industry giant Silencer Shop and advocacy groups like Gun Owners of America plan to facilitate transfers of these newly untaxed items immediately, bypassing the traditional Form 4 paperwork entirely. This shift would fundamentally alter the retail landscape for firearms accessories. Instead of waiting up to a year for federal approval, Qualified buyers could potentially walk out of a store with a suppressor in a fraction of the time. The removal of the Form 4 requirement represents the dismantling of a massive bureaucratic gatekeeper. For decades, the Bureau of Alcohol, Tobacco, Firearms, and Explosives has used this form to maintain a detailed registry of every owner, a practice that gun rights advocates have long criticized as an infringement on constitutional rights. By bypassing this form, the plaintiffs are not just streamlining a purchase, they are actively dismantling the federal registry for these specific categories of firearms. The logistics of this transition are already being put into place, with digital platforms preparing to process transactions under the new legal guidelines the moment the clock strikes midnight. This preparation shows that the industry is ready to move instantly, turning a temporary legal window into a permanent shift in how these items are distributed across the country. This particular aspect is key to understanding the broader impact of the development. By breaking down these elements, we get a much clearer picture of the situation. However, this transition is not a simple blanket deregulation. The injunction issued by Judge Hendricks is highly specific, applying strictly to the named plaintiffs, their members, and their customers. This creates a fragmented legal landscape where an individual must fall within this protected class to legally bypass the federal registration system. For the average citizen who does not belong to these specific organizations, the transaction remains a federal felony, which explains the sudden surge of interest in joining these advocacy groups. Even for those covered, the practical execution of these transfers remains highly uncertain. Licensed gun dealers, known as federal firearms licensees, face a massive compliance dilemma. If they transfer an item without a completed Form 4, they risk severe administrative penalties or criminal charges if the ruling is suddenly stayed or overturned. Dealers must weigh the text of the injunction against the potential wrath of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, which has not yet issued official guidance on how it will respond. Furthermore, state-level restrictions on suppressors and short-barreled rifles remain fully in effect, meaning local laws could still block transfers even if the federal government is temporarily sidelined. Because of these overlapping risks, legal experts urge extreme caution, advising buyers and dealers to wait until August 13th to see if the dust settles before attempting any transactions. This warning is a necessary shield against a complex legal trap. A buyer who completes a transfer in the early morning hours could suddenly find themselves holding an unregistered item if a higher court reinstates the registration requirements shortly thereafter. Until these overlapping legal and administrative questions are answered, the transition remains a minefield for everyone involved, requiring absolute precision from dealers and consumers alike. By breaking down these elements, we get a much clearer picture of the situation. Analyzing these components reveals the underlying forces at play in this scenario. Despite these risks, the systemic pressure this case creates could trigger a rapid, nationwide collapse of these federal regulations. If a massive portion of the American public can legally acquire suppressors and short-barreled rifles without paying a tax or waiting months for federal approval simply by joining an advocacy group, the National Firearms Act becomes practically unenforceable on a macro scale. This structural imbalance places immense pressure on both the executive branch and Congress. The legislative branch is now caught in a trap of its own design. To fix this vulnerability, Congress would have to pass new legislation raising the tax back above $0. However, in the current polarized political climate, voting to reinstate a federal gun tax is a non-starter for many lawmakers, meaning legislative relief for the federal government is highly unlikely. This legislative gridlock means that the executive branch cannot rely on Congress to patch the hole in the law. Instead, the burden falls entirely on the Department of Justice to defend a broken system in the courts. If the government cannot enforce the registration requirements, the entire regulatory framework of the National Firearms Act could begin to unravel, as other parts of the law rely on the same constitutional justifications. This pressure is not just legal, it is highly political, forcing lawmakers to choose between supporting gun control measures and avoiding the implementation of new taxes on their constituents. The resulting standoff highlights the fragile nature of federal gun laws that rely on tax codes rather than direct police powers, exposing a structural weakness that could lead to a broader deregulation of restricted firearms across the United States. This particular aspect is key to understanding the broader impact of the development. By breaking down these elements, we get a much clearer picture of the situation. Analyzing these components reveals the underlying forces at play in this scenario. Meanwhile, the Department of Justice faces a high-stakes dilemma that could shape the future of the Second Amendment for decades. If they choose not to appeal the ruling, they allow a major precedent to stand, effectively inviting other federal courts across the country to adopt Judge Hendricks's reasoning. But if they do appeal to the United States Court of Appeals for the Fifth Circuit, they risk a binding appellate ruling that could permanently dismantle these provisions across multiple states. This dilemma has created a sense of optimism among gun rights advocates, who see this case as a historic opportunity to weaken federal oversight. If the morning of August 13th arrives without a last-minute intervention, the firearms community will enter uncharted legal territory. For the first time in nearly 90 years, a significant portion of the American public could legally acquire suppressors and short-barreled rifles without federal registration. This outcome represents a monumental shift, demonstrating that the federal government's regulatory framework can be dismantled using the state's own legislative mechanisms. Yet, this victory highlights a growing trend of regionalized constitutional law, where federal regulations apply to some citizens but not others based on court jurisdictions and organizational memberships. The Department of Justice cannot allow such a massive gap in federal authority to persist indefinitely without risking the total collapse of the National Firearms Act. As the deadline passes, the focus shifts from temporary court orders to the long-term survival of federal gun control itself, setting the stage for a final, high-stakes showdown over the limits of executive power and the constitutional boundaries of federal taxation. That practical detail is what keeps the section anchored to a clear, real-world point. Examining these specifics helps clarify how the overall mechanism functions in practice. This particular aspect is key to understanding the broader impact of the development. By breaking down these elements, we get a much clearer picture of the situation. The next enormous question is how the federal government will navigate this self-inflicted constitutional crisis. By reducing the tax to $0, Congress inadvertently pulled the thread that could unravel decades of federal gun control. Whether the Department of Justice mounts a late-night rescue or allows the deadline to pass, the legal landscape has permanently shifted. For now, the nation waits to see if this temporary loophole becomes a permanent gateway to deregulation, or if a higher court will step in to restore the status quo. The clock is ticking, and the answer will reshape the Second Amendment landscape for generations to come.